Good afternoon. My name is François Tanguay-Renaud. I'm a professor here at Osgoode Hall Law School. I'm also the co-director of the Jack and May Nathanson Center on Transnational Human Rights, Crime, and Security. And it's my pleasure this afternoon to welcome you to the 2008 Emet lecture. A few words about the lecture. The Emet Fund was established a long time ago now, in 1976, to promote the study of law in the broadest sense. The fund in itself seeks to promote, through public discussion, research, and scholarly writing, public and professional appreciation of the significance of things like religion, ethics, culture, and history in the development of the legal system. Emet, what does this mean? Well, it means the light of truth. So the lecture really seeks to shed light on matters that perhaps deserve a bit more truth, or truth-telling, as it were. In 2010, the Nathanson Center, of which I'm co-director, decided to pool its resources with the Emet Fund to ensure that the lecture would be delivered on an annual basis. So as a result, the themes that are now explored by the lecture tend to relate, at least tangentially, to the mandate of the center. Now this year, we're delighted to have with us Jameel Jaffer, who will already be known, most likely, to many of you. Jameel is the inaugural director of the Knight First Amendment Institute at Columbia University. But he also previously served as Deputy Legal Director at the American Civil Liberties Union, the ACLU, where he oversaw that organization's work on free speech, privacy, technology, national security, as well as international human rights. Jameel has argued civil liberties cases in multiple appeals courts in the US, as well as in the US Supreme Court, and he's testified many times before the US Congress. His cases include some of the most significant post-9/11 cases relating to national security as well as civil liberties, including cases concerning detention, interrogation, surveillance, targeted killing, and government secrecy. He actually co-led the litigation that resulted in the publication of the Bush administration's torture memos, which is a lawsuit that the New York Times described as among the most successful in the history of public disclosure in the United States. Jameel also led the ACLU's litigation that resulted in the publication of the Obama administration's drone memos. And most recently, with the Knight's First Amendment Institute, he's also litigated groundbreaking freedom of speech cases. His recent writing has appeared in multiple publications, including the New York Times, the Los Angeles Times, the Guardian, the Nation, and the Yale Law Journal Forum. He's an executive director of Just Security, which is a national security blog, and he has two best-selling books under his belt. His first book, Administration of Torture from Washington to Abu Ghraib, and Beyond, was co-authored with Amrit Singh and was published by Columbia University Press in 2007. And more recently, the Drone Memos, published by the New Press in the fall of 2016. Jameel is a graduate of Williams College, the University of Cambridge, and Harvard Law School. He has served as a law clerk to the Honorable Amalia Kearse of the U.S. Court of Appeals for the Second Circuit, and he's also been a law clerk to the Right Honorable Beverly McLaughlin, Chief Justice, or former Chief Justice of the Supreme Court of Canada. So I should emphasize here that despite the fact that Jameel has built most of his career south of the border in the United States, he's still very much a Canadian, and thankfully he told me yesterday that he still identifies as such. So, and he's actually been involved with many organizations on this side of the border, including the Canadian Civil Liberties Association. He's actually a distinguished fellow of the Monk School of Global Affairs and Public Policy, and many other organizations. So we're really delighted to welcome Jameel here at Osgoode Hall Law School, York University, today to deliver the 2018 Emet lecture on the topic of digital journalism and the new public square. Now, just a few words about format. Jameel tells me that he's going to speak for about 30 to 40 minutes, and then we're going to open to questions from the floor for an approximate 30 to 40 minutes once again. So without further ado, please join me in welcoming Jameel Jaffer. Thank you.
Thank you. Thank you, Professor Tanguy Renaud, and thank you, all of you, for being here. So I haven't lived in Toronto for more than a quarter century, which is difficult for me to say, let alone believe. But I'm always delighted to be invited to speak here because I still have many friends and family in and around Toronto. It's also an honor to be asked to deliver this particular lecture, though as you can probably imagine, it's a little bit intimidating to have to deliver a lecture whose name promises the light of truth. So in the spirit of managing expectations, let me just say right up front that I can aspire to, at most, a faint flicker of truth through a heavy fog. So that's what I'll try for. A few months ago, The Guardian published a remarkable story revealing that a Cambridge University researcher had harvested as many as 50 million Facebook profiles for Cambridge Analytica, which is a data analytics firm that was headed at the time by Steve Bannon, one of Donald Trump's key advisors. And the researcher, Alexander Kogan, collected the profiles with an app called This Is Your Digital Life. And through the app, he paid Facebook users small amounts of money to take personality tests and to consent to their collection, to the collection of their data for academic purposes. And then Kogan turned the profiles over to Cambridge Analytica, which used them, The Guardian said, to predict and influence American voters' choices at the ballot box. The Guardian story relied in significant part on the account of Christopher Wiley, a Canadian researcher who had helped establish Cambridge Analytica and who later worked with Kogan on the Facebook project. Wiley told The Guardian, quote, "We exploited Facebook to harvest millions of people's profiles, and we built models to exploit what we knew about them and target their inner demons. That was what Cambridge Analytica was built on," he said. Most of you probably remember that story. You may not be familiar, though, with what happened the day before it was published. As The Guardian's editors were readying their story for print, the lawyers received a letter from Facebook. And the letter threatened a lawsuit if The Guardian went forward with the story. Facebook knew that the story would provoke disbelief and outrage, and perhaps even a regulatory response by the US Congress. So it tried to quash the story with the threat of a lawsuit. Now, there's nothing unusual, unfortunately, about powerful actors threatening litigation to preempt unflattering news coverage. Intimidating letters of the kind that Facebook's lawyers sent to The Guardian are a staple of the media sphere in the United States and in the United Kingdom, and they're probably a staple of the media sphere here in Canada, too. But Facebook isn't just any powerful actor. It's one of the largest corporations in the world. It has more than 2 billion users, more than 200 million of them in the United States. And through its human and algorithmic decision-making, it has immense influence on how its users engage with one another and with the communities around them. It's no accident that stories about political polarization and filter bubbles and election integrity, the spread of disinformation online, voter suppression in Brazil, mob violence in Sri Lanka, and even ethnic cleansing in Myanmar have Facebook as their common denominator. Facebook has an invisible but powerful influence on what we would once have called the public square. And through that influence, Facebook affects societies all over the world. So what are the mechanics of that influence? In a new article, the legal scholar Kate Klonick argues that the social media platforms should be thought of as, quote, systems of governance, because they're now the principal regulators of speech that takes place online. Through their control of the new public square, the platforms are exercising power we ordinarily associate with state actors. One facet of that power, the facet that Klonick explores in her article, is sometimes called content moderation, by which we usually mean the determination of which speech should be permitted on these privately controlled platforms and which shouldn't be. Facebook, for example, routinely removes user content that shows graphic violence or nudity, as well as hate speech, as Facebook defines it, and speech glorifying terrorism, again, as Facebook defines it. The other major platforms have similar policies. There's an ongoing debate about the ways in which the companies are exercising that power, whether they're taking down too much speech or too little speech, or perhaps even both. In an essay published over the summer by the Hoover Institution, Daphne Keller, who's a researcher at Stanford, observes that people from across the political spectrum are convinced that the platforms are silencing speech for the wrong reasons. This debate is important because increasingly it's the platforms rather than governments that delineate the outer limits of public discourse, and also because the platform's power to censor isn't subject to constitutional or regulatory constraint. But content moderation, at least in the narrow sense of that phrase, hardly begins to describe the platform's influence. The social media companies' more fundamental power over public discourse is reflected not principally in their decisions about which speech to exclude from their platforms, but in their decisions about how to organize and structure the speech that remains. They dictate which kinds of interactions are possible and which aren't, which kinds of speech will be made more prominent and which will be suppressed, which communities will be facilitated and which will be foreclosed. If the new public square were an ocean, Facebook would control not only which fish got to swim in it, but also the temperature and salinity of the water, the force and direction of the currents, and the ebb and flow of the tides. But despite the role that Facebook and other platforms now play, our collective understanding of them is very limited, and we sometimes struggle even to describe what they are. When is a platform a publisher? When is it a common carrier? For the past year, the Knight Institute, the institute that I direct, has been litigating a First Amendment challenge, a free speech challenge, to President Trump's practice of blocking critics from his Twitter account. The case turns on the question of whether the president's account, @RealDonaldTrump, is a public forum. The litigation has been a competition of analogies. Is the president's notorious Twitter account like a town hall or a park? Or is it more like a radio station or a telegraph? Heather Whitney, a philosopher and legal theorist, has written a fascinating paper about whether the social media companies are properly thought of as editors. Her paper is further evidence that we're still trying to figure out what the platforms are and which legal labels to attach to them. Last year, the US Supreme Court decided an important case involving the First Amendment right of access to social media. The decision was unanimous, but Justice Kennedy, who wrote the court's opinion, and Justice Alito, who concurred in it, disagreed about whether the platforms in their entirety should be characterized as public forums. At some level, both justices seemed to understand that the conceptual vocabulary available to them was inadequate. Justice Kennedy wrote, quote, "While we now may be coming to the realization that the cyber age is a revolution of historic proportions, we can't appreciate yet its full dimensions and vast potential to alter how we think, express ourselves, and define who we want to be." He continued, "The forces and directions of the internet are so new, so protean, and so far-reaching that courts must be conscious that what they say today might be obsolete tomorrow." If our collective understanding of the platforms is limited, it's in large part because the social media companies have guarded so jealously the information that would help us understand them. Over the last few years, they've begun to share information about instances in which governments compel them to remove user-generated content or compel them to turn over user-sensitive data. They've begun to share information about the limits they themselves impose on the kinds of information and the kinds of content that users can post on their platforms. Just a few months ago, Facebook released the internal guidelines it uses to enforce its community standards, a release that marked what the Electronic Frontier Foundation described as a sea change in Facebook's reporting practices. These disclosures are commendable, but they're also overdue and incomplete, as the Electronic Frontier Foundation also observed. Perhaps under new pressure from the public and from regulators around the world, the companies can be compelled to reveal more. Let's also recognize, though, that one reason the companies aren't more transparent is that they themselves don't fully understand the decisions that they're making. Sometimes this is by choice. The Guardian journalist who broke the Cambridge Analytica story spoke to an engineer who had once been in charge of policing third-party app developers at Facebook. The engineer said he'd tried to warn Facebook about the growing black market for its user data. Facebook wasn't interested in hearing about it, he said. He told The Guardian, quote, Facebook was in a stronger legal position if it didn't know about the abuse that was happening. They felt it was better not to know. It would be a mistake to think that public ignorance in this context is simply a result of the company's refusal to release information. The information we most need, the companies don't have. The companies are engaged in a massive social experiment with no precedent in human history. They rely increasingly on continuously evolving machine-generated algorithms whose complexity defies understanding. They don't understand their own platforms, and still less do they understand their platform's broader social and political implications. When Facebook was asked about the reach of disinformation in the months preceding the 2016 presidential election in the United States, it first said that 10 million people had seen political ads posted by accounts linked to the Russian Internet Research Agency. Jonathan Albright, who's a researcher at Columbia's journalism school, then reported in the Washington Post that 6 Russia-linked pages alone had reached 19 million people. Earlier this year, Facebook conceded that content posted by Russia-linked accounts had reached as many as 126 million people. If Mark Zuckerberg's recent congressional testimony showed anything, it's that Facebook is a black box even to Facebook. Zuckerberg himself has sometimes acknowledged this. In a recent interview, he conceded, "It's tough to be transparent when we don't first have a full understanding of the state of some of our systems." Against that background, and now I'm finally getting to my point, we should recognize that independent journalism and research about the social media platforms is extraordinarily valuable, and that obstacles to this kind of journalism and research are especially problematic. To the extent these obstacles impede us from understanding the forces that invisibly shape public discourse, they're best thought of as obstacles to self-government. We should view them, I think, in much the same way we'd view laws that prevented us from reading federal statutes, or attending congressional hearings, or accessing judicial opinions. They impede us from understanding the forces that govern us. Last-ditch legal efforts to block stories before they go to print, like the letter that Facebook's lawyers sent to The Guardian, aren't by any means the only obstacles worth worrying about in this context. Perhaps the most significant impediments to journalism and research about the social media platforms arise from the company's terms of service, which bar journalists and researchers from using digital tools that are indispensable to the study of the platforms at scale. Most significantly, all the major social media companies bar users from collecting information from their platforms through automated means. Journalists and researchers can collect this information manually, but most of the platforms forbid them from collecting it using computer code. The prohibition is significant because it's impossible to study trends and patterns and information flows without collecting information at scale, and it's practically impossible to collect information at scale without collecting it digitally. The effect of the prohibition is to make some of the most important journalism and research off limits. Some platforms, including Facebook, also prohibit the use of temporary research accounts, the kinds of accounts that could allow journalists and researchers to probe the platform's algorithms and to better study issues of discrimination and disinformation online. This prohibition, too, prevents journalists and researchers from doing work we need them to do. These impediments are substantial in themselves, but in the United States, they're made even more so by a federal statute called the Computer Fraud and Abuse Act. The U.S. Justice Department understands that statute to impose civil and criminal penalties on those who violate the social media platform's terms of service. On the Justice Department's reading, the law makes it a crime for a journalist or researcher to study the platforms using basic digital tools. The very existence of the law discourages journalists and researchers from undertaking projects that are manifestly in the public interest. Projects focused on, for example, the spread of disinformation and junk news, political polarization, and unlawful discrimination in advertising. Anyone who undertakes a project like that does it under the threat of legal action by the Justice Department and the social media platforms. When journalists and researchers do undertake the projects, they often modify their investigations to avoid violating terms of service, even if doing so makes their work less valuable to the public. In some cases, the fear of liability leads them to abandon projects altogether. Now, I want to acknowledge right away that the social media companies may have good reasons for generally prohibiting the use of these digital tools on their platforms. Facebook's prohibition against automated collection is presumably meant, at least in part, to impede the ability of commercial competitors, data aggregators, and others to collect, use, and misuse the data that Facebook's users post publicly. Facebook's prohibition against the use of fake accounts reflects, in part, an effort to ensure that users can feel confident that other users they interact with are real people. Intentionally or not, though, Facebook is also impeding journalists and researchers' ability to study and understand and report about the platform. It's difficult to study a digital machine like Facebook without the use of digital tools. Trying to study Facebook without the use of these tools is like trying to study the ocean without leaving the shore. I want to return to a point I made earlier, that we should think of independent journalism and research about the platforms as especially valuable, and that we should think of obstacles to them as especially problematic. Half a century ago, the US Supreme Court decided New York Times versus Sullivan, which is the landmark case that established crucial free speech protections that American publishers rely on even today. The case, as some of you may know, arose out of an advertisement in the New York Times that solicited contributions for the Committee to Defend Martin Luther King and the Struggle for Freedom in the South. And the ad accused certain public officials in the American South of harassing civil rights activists and using violence to suppress peaceful protests. L.B. Sullivan, the Public Safety Commissioner of Montgomery, Alabama, filed a libel suit against 4 of the clergymen who had signed the ad, and also against the New York Times, which had published it. The case was tried in Alabama, and the jury awarded $500,000 in damages, but the U.S. Supreme Court reversed. In his opinion for the unanimous court, Justice Brennan explained that the First Amendment was intended first and foremost to ensure the freedom of public debate on what he called public questions. Quoting an earlier case, he wrote, "The maintenance of the opportunity for free political discussion to the end that the government may be responsive to the will of the people is a fundamental principle of our constitutional system." And in his opinion's most celebrated passage, he invoked the United States, quote, "profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open." Justice Brennan was focused in particular on speech critical of government officials, because the case before him involved exactly that kind of speech. But the key insight behind his opinion has broader implications. The insight is that the First Amendment was intended most of all to protect the speech necessary to self-government, or as Harry Calvin Jr. put it in a now famous essay published only months after the New York Times case was decided, the central meaning of the First Amendment is, quote, "to protect the speech without which democracy cannot function." Now, it hardly needs to be said that there is a large distance between the question that was presented to the court in the New York Times case and the questions I started off with today. But it seems to me that in an era in which the social media companies control the public square, in an era in which these companies are, in a very real sense, our governors, journalism and research focused on these companies implicates the very core of the First Amendment. Journalism and research that help us better understand the forces that shape public discourse and that help us hold accountable the powerful actors that control those forces is speech essential to self-government. It's what the First Amendment is for. So I'd like to offer just a few preliminary and tentative thoughts about what the companies, the courts, and legislatures could do to better protect the kind of journalism and research I've been describing, and more generally to ensure that the public has the information it needs in order to understand the new public square and to hold accountable the companies that control it. If we were committed to these goals, what kinds of policy reforms might we ask for? Well, we might ask first that the companies be more transparent about the ways in which they're shaping public discourse. David Kaye, who's the United Nations Special Rapporteur for Free Expression, issued a report several months ago urging the companies to disclose, quote, radically more information about the nature of their rulemaking and enforcement concerning expression on their platforms. In a report filed with the UN Human Rights Council, Kaye recommended that companies issue public opinions when they remove content from their platforms so that users and others can better understand why the content is being taken down, and so that they can challenge the company's decisions when they believe the company's decisions are unjustified. Those seem like good ideas to me. As Kaye says, quote, in regulation of speech, we expect some form of accountability when authorities get it wrong. We should see that happening online too. But we need the platforms to be transparent, not only about what speech they're taking down, but about how they're shaping the speech they're not taking down. What kinds of speech and associations are they privileging? And what forms does this privilege take? What kinds of speech and associations are they marginalizing? And what forms does that marginalization take? Kaye's report had a different focus, but he highlighted the need for transparency about a specific form of content curation. Quote, if companies are ranking content on social media feeds based on interactions between users, he wrote, they should explain the data collected about such interactions and how this informs the ranking criteria. The more general point is that the companies should be more transparent about how they're shaping public discourse. They should be more forthcoming about the forces at work in the new public square. Here's a second possible avenue for reform. We could ask the social media companies not to enforce their terms of service against those who use digital tools on their platforms in the service of bona fide journalism and research. Again, many of the companies themselves, many of the questions that are most urgent right now are questions the companies themselves aren't able to answer. The companies should be facilitating, not obstructing, the work of journalists and researchers and others who might be able to provide answers where the companies can't. Even if the companies have legitimate commercial privacy or security reasons for generally prohibiting the use of certain digital investigative tools, it should be possible for them to create a kind of carve-out, a safe harbor that expands the space for these activities while protecting the privacy of their users and the integrity of their platforms. Incidentally, the data privacy regulation that went into effect in Europe over the summer supplies a conceptual framework for exactly that kind of safe harbor. As a general matter, the new regulation places significant restrictions on the use of digital tools to collect and analyze and disseminate information obtained from social media platforms. But the regulation also encourages individual countries to exempt journalism and research from those general restrictions. A handful of countries, including the UK, have already recognized exemptions of this kind. European privacy legislation, in other words, distinguishes between those who use digital tools for private or nefarious purposes and journalists who use those tools to inform the public about matters of public concern. The company's terms of service should be similarly discerning. The companies can protect their users' privacy and their platform's integrity without categorically prohibiting digital journalism and research that is overwhelmingly in the public interest. A third possibility: we could ask the courts to refuse to enforce the company's terms of service against those who responsibly use digital tools in the service of bona fide journalistic and research projects. As a general matter, courts enforce contracts as written, and as a general matter, they should enforce terms of service too. But there are contexts in which courts decline to enforce contractual provisions that conflict with public policy. Often these cases involve contractual terms whose enforcement would disable democratic institutions or processes. For example, where a contract would prohibit a person from running for office, or from criticizing public officials, or from disclosing information of overriding public importance. Those cases are surely relevant here. For reasons I've already explained, journalism and research focused on the platforms is of special democratic importance because of the unique role that these companies play in shaping public discourse. Terms of service that impede that kind of journalism and research are in tension with our commitment to self-government, because again, they impede us from understanding the forces that profoundly shape our interactions and our communities and our democracy. Here, finally, is a fourth possibility. We could encourage the US Congress to amend the Computer Fraud and Abuse Act so that digital journalists and researchers can do their work without the risk of incurring civil and criminal penalties. Journalists and researchers who are investigating questions that implicate the very core of the First Amendment's concern shouldn't have to operate under the threat of legal sanctions. Let me just close by bringing us back to the Guardian story I started with. That story about Cambridge Analytica is in part a reminder that the platforms are entirely justified to worry about the ways in which their users' data can be exploited by third parties. It should also be a reminder, though, of how reliant we are on the work of independent journalists and researchers. If we want to understand the platforms, if we want to understand the new public square, journalism and research about the platforms is crucial, and it deserves special solicitude under our law. Whatever free speech means in the digital age, it should encompass robust protections, I think, for this kind of public interest journalism and research. Thank you.
Well, thank you very much, Jameel, for this very thought-provoking lecture. So we have plenty of time, actually, for questions. Now, this is being video recorded, and we have one microphone. So if you have a question, please wait until I reach you so you can speak into the microphone. Who will start us off? Professor Priel.
Thank you. This is really, really interesting. So I have a question. So you tied the proposals that you make to the US approach to free speech and New York Times. But could it be that that approach nowadays is part of the problem rather than part of the solution? So underlying this approach is one that proclaims those three famous words of Brennan, what is it?
Robust, uninhibited, wide open.
Exactly.
Yeah.
But in fact, you can look at it in a different way and say, it's a form of privatization. So it privatizes the regulation of speech. And interestingly, people who in other contexts are very, very favorable to the idea that private business should be regulated by government, in this context are saying we should not regulate speech, and in fact nowadays we shouldn't even regulate those who regulate speech, the private companies that regulate speech. Now this may have been great in the 60s, but now leaving this domain completely of Facebook, Google, and so on, completely unregulated is perhaps not sufficient to address the kind of problems that we have. And perhaps, and I actually never thought about this until now, the basis for distinction is something like speech versus information. So you can be as free with your speech, but these companies trade in information, and that's something else where government may want to be more heavily involved with regulating it. So now, of course, there are risks there, but yeah, that's my question.
So I generally agree with you that the approach that we have taken until now is not up to the task. I don't see the problem as a problem with New York Times versus Sullivan, or at New York Times versus Sullivan, to the extent it just means that we want to make sure that debate about what Brendan called public issues or public questions is uninhibited and robust and wide open. I'm all for that. I don't see any problem with that. I think that the problem is a doctrinal one that is more recent. And there has been a shift over the last 50 years towards a much narrower conception of free speech, which focuses myopically on speakers, right? And is indifferent, and to people who are not in this debate, it seems obvious that that free speech should focus on speakers, but it's actually not so obvious, right? Because there are other participants in the marketplace of ideas. There are speakers, but there are listeners. There are also, when it comes to social media platforms, users. There's society more generally, which is supposed to be the beneficiary of this marketplace of ideas. And so I think that the solution here is to reverse that doctrinal trend. And many of the most important free speech questions right now that are coming before the US Supreme Court, at least, are questions in which there are at least arguably free speech interests on both sides of the V, right? So if you think of these social media cases, Facebook or Twitter, they argue that they have the First Amendment right to create the expressive communities they want to create. They are editing or they're publishing, and they should be entitled to the same First Amendment rights as any other editor or publisher. And to me, that's not an implausible argument. The problem is that they're not the only, their First Amendment interests aren't the only ones at stake in these, in these contexts. They have interest in creating the communities they want to create, but users also have free speech interests in being able to participate fully in public discourse. Society has an interest in ensuring that these platforms don't undermine other important societal interests, including the interest in fair elections, right? And so I don't like viewing these First Amendment questions or these free speech questions through a very narrow lens focused on speakers alone. And I think that we are going to have to think about how to reconcile or balance the rights, again, which don't seem to me trivial. I think Facebook does plausibly have the right to create its own expressive community. But we need to balance that against other societal interests. And the doctrine we have in the United States right now doesn't do that very well. And you see that not only in cases involving new communications platforms, but you see it in cases involving campaign finance or cases involving commercial speakers, where there is this very narrow focus on the rights of the speaker. And in my view, insufficient attention given to the free speech implications of those decisions for other participants in what is sometimes called the marketplace of ideas.
Thanks. Dahi Makshi, I'm a visiting fellow at the school and based at Queen's University Belfast. I wonder whether you think there's a need to go beyond the sort of the shield argument. I mean, much of the case you've laid out, which is a very compelling case, is predicated on the technological ability of the journalist or the researcher to work out what's going on, which might be presumptively unlawful, but then trumped by one of the illustrations you've laid out. Should we also consider or expect that the platforms in question might seek to frustrate, either by not recognizing that they're frustrating an investigation through their own data management and systems practices, or, as we've sometimes seen with some of the sharing economy companies, deliberately seeking to interfere with investigation. We've seen, for instance, Uber try to develop tools that are both clever and wicked in recognizing when a regulator is logging on and giving them a different version of the service. It's wouldn't be surprising to see similar happening with a journalistic investigation. So whereas, say, the GDPR in Europe does give a broad protection for researchers, it doesn't do as much, or some hints at it, requiring disclosure of how an algorithm operates or providing access to data, as we would, for instance, with classic public authorities, where there may be an access to information right or some way of requiring an explanation. So does the argument you outline lend itself to...
Go far enough?
Yeah, but maybe more of the positive obligation school rather than the shield school. Thank you.
So this is... in terms of U.S. constitutional doctrine, my argument is quite ambitious. In terms of, in any other terms, it's a very modest argument, right? My argument is ambitious only because U.S. constitutional doctrine is so constraining. But I will not pretend that what I'm proposing is a complete solution to the problems that I've, described. I think that we can ask the social media companies to be more transparent, and we should. And journalism and research focused on them can create a kind of pressure to, a pressure that they will feel to be more, more transparent. I don't think we should rule out the possibility of regulation that requires them to disclose information. It's a complicated question what that disclosure would look like when it comes to, so you can distinguish between two forms of censorship that the platforms engage in. I don't mean to, I'm using censorship in a value neutral way here. The platforms decide who can be on their platforms, right? The companies decide who can be on the platforms and what can be said, right, by setting up the community standards. So that's kind of threshold censorship. Who gets into the ocean in the first place, right? And then there's a kind of environmental or interstitial censorship that the platforms engage in, which is much less visible and probably more consequential, shaping the speech by deciding which speech goes viral and which speech disappears into the void. So transparency as to the first forms of censorship is relatively straightforward, right? You could demand, as David Kaye has, and many others have, you could demand that the social media companies, and you could require them to do this, disclose what speech have they taken down, what speakers have they taken down. You could require them to issue public opinions explaining their decisions, although the scale presents a challenge because they make these decisions thousands of times a day. But that's relatively straightforward. What transparency looks like with respect to environmental or interstitial censorship is much more complicated. Some people have called for algorithmic transparency, meaning require the platforms to disclose the algorithms that underlie those speech environments. But again, as I said, the platforms themselves don't fully understand the algorithms. The algorithms are continuously evolving. They're based on machine learning. Machines are adapting to a continuously changing environment. And if they were to disclose their algorithms, nobody else would understand them either. And so, you can require them to disclose major inputs. That would be one possibility, and some of the platforms have made a move in that direction already. In blog posts, they will discuss how certain things end up at the top of your newsfeed and how others get relegated to the bottom. But that is a coarse form of transparency. I think of journalism and research as output transparency rather than input transparency, right? So the journalism and research isn't telling us what the algorithms are, but they're telling us It's telling us what the results of the algorithms are. And there is many journalists and researchers think that that form of transparency is ultimately more important because what you don't get from input transparency, even if we were even if Facebook showed us its algorithms and we fully understood its algorithms, arguably more important than the algorithms are the data that Facebook is feeding into the algorithms, and you don't get that from the algorithmic transparency. The only way you understand the interaction between the algorithm and the data is by studying the output, which is what journalists and researchers do. So, that's just a long way of saying I think that the solution has to involve some combination of input transparency and output transparency, meaning some combination of requiring the companies to disclose more and allowing journalists and researchers to explore more freely. And I think in the long run, the set of solutions here probably has to include a combination of self-regulation on the part of the platforms and regulation imposed from the outside by government. My proposals are also modest in another sense, in that I'm focused entirely on transparency. Right now, transparency in a maybe not the narrowest sense of transparency, but nonetheless transparency. But even if you had all the transparency that I've asked for, there's still the question of, we would know what the platforms are doing, but what should we think of what the platforms are doing? That's a separate set of questions, which is much more complicated than the set of questions that I've tackled. In my view, what Facebook and Twitter and Instagram and YouTube are doing would be not worth losing any sleep over if these companies were smaller than they are. Everything, all the problems turn on scale. They stem from scale, and the magnitude of their implications or societal implications is a result of their scale. And if you agree with me that the problem, the central problem is a problem of centralization of power over the speech environment, then it may be that the most direct solution isn't a kind of free speech regulation, but rather antitrust or anti-monopoly regulation, where you break up the companies in some way or somehow lower the barriers to entry into the marketplace in the real sense, into this sector of social media. And there are various ways you could do that. You could do that, again, by breaking up the companies, but you could also do it through data portability requirements, just making it easier for people to move from Facebook to some new platform, right? Those forms of regulation might be a more direct way of addressing some of the problems, certainly the centralization problem. And in some ways, they're less, they raise fewer difficult questions because, regulation of speech, which is the other option, would run into immediate doctrinal barriers in the United States, and I think would run into immediate value barriers, not just in the United States, but in most democracies. People don't like the idea of governments dictating to private entities what content, what viewpoints they can carry and what viewpoints they can't. And antitrust or anti-monopoly options don't raise those concerns, at least not to the same extent. Sorry, it's a very long answer to what was probably a simple question.
Professor Bandyopadhyay.
Thank you, Jameel. This was great. I think your paper, if this is a paper, does a lot already in the sense that it moves beyond gatekeeping regulation to look at the environmental modification, the sort of expansive effects of that on both users and producers of content. But my question is that, so from what I understand, as you said, this is a transparency argument, but it seems a little asymmetric to me in that it's missing a dimension. So for instance, in the classical understanding of free speech, of the marketplace of ideas, it was ideas for their own sake. and it was the more speech, the better, right? And you want to encourage that marketplace of ideas. And that is the classical American understanding of it. But of course, we now know, and as you acknowledge, that there is an economic dimension to speech. The reason these companies are powerful is because they monetize speech, and they're able to do things with speech, and people listening to each other are able to monetize information, right? So to the extent that your solutions, if I have them right, of either don't have the terms of service, or Facebook should agree not to enforce them in case of research, or courts should not enforce them in cases of research, or the legislature should amend this statute. To my mind, they run into not the free speech, sort of the old-timey free speech understanding, but they run into an economics problem, which is that the terms of service exist, and the courts exist, and this particular legislation exists because, as a matter of value, people see the economic benefits, the economic side of free speech as important, and the sort of private corporation side of free speech as important as free speech for its own sake. And this is can corporations have speech, to do with campaign finance and things like that. There is now an equation between these two values of free speech for its own sake and free speech as an economic value to society. So they're both in the public interest. So my question is that without measuring the economic side of this, is it really, to what extent would you say it's reasonable to expect the courts or the corporation or the legislature to want to undo or unravel the system at all? Aside from their ideological commitment, there's also an ideological commitment on the economy side. So could you say a little more about how you think that side would play into your argument? Thank you.
That's a very hard question. So I don't think that there is a strong argument that categorically prohibiting these forms of journalism and research is necessary to serve economic interests. I think that a safe harbor for journalism and research would add, just to think of it in a very sort of crass ledger, sort of pros and cons way. The pros would be the public would have more information about the platforms, and the cons would be very limited, even if you take economic costs into account. These rules were put in place long before anyone had thought about social media platforms. The Computer Fraud and Abuse Act is a 1980s statute. The concern was hacking. It's just that the law was drafted so broadly that when the social media companies came along, they saw in the law the possibility of strengthening the prohibition in their terms of service against this form of digital journalism and research. So they've taken advantage of the breadth of the law, but the law doesn't reflect a congressional judgment that banning this form of journalism is necessary or that it serves some economic end. The law was drafted before anyone, before Facebook was a gleam in Mark Zuckerberg's eye. So the hope now is that we can go back to the legislature and say, draft a narrower law. Draft a narrower law that preserves Facebook's economic viability, that preserves Facebook's ability to protect the integrity of its platform, preserves Facebook's ability to protect its users' privacy. I don't like saying Facebook's protecting its users' privacy because it's ridiculous. But that's the argument that they make, is that they use privacy in a very stylized way. What they mean is protect our own ability to exploit our users' data, but prevent anyone else from exploiting it. The hope is we can go back to Congress and say, now that we have a better sense of now that we know how the law is being used today, draft a narrower law. And with respect to, so I didn't mention it, but this safe harbor idea, this idea of the social media platforms creating a safe harbor voluntarily for this kind of journalism and research. Voluntariness is a spectrum, right? And Facebook is responding to public pressure right now. Facebook's under a lot of public pressure to respond to the major news stories that have exposed the various pathologies on Facebook's platform that lead to some of the things I was talking about earlier, disinformation or the undermining of elections. And my institute, we sent a letter to Facebook maybe 6 weeks ago proposing that they adopt a safe harbor for these forms of journalism and research. And we spelled out in significant detail what we meant by public interest journalistic and research projects. And we provided a draft of an amendment to their terms of service. And I will not say that they jumped at the opportunity to create that safe harbor, but they responded graciously and invited us to come in and talk with them about it. And we've now had a couple conversations with them, most recently just a few days ago, where we spent 2 hours talking to Facebook's lawyers and engineers about whether something like this would be workable. And I am not suggesting that I'm confident that this is going to happen. I'm definitely not. But we would not be getting this kind of response from Facebook if they didn't feel some public pressure now to answer the kinds of concerns that we're raising. So that's just to say that we're in an environment in which I think these kinds of reforms are at least on the table, which is more than we could have said 2 years ago. And I think it's worthwhile to think about how to exploit this moment, especially since we don't know how long this moment will last.
Yes, can you introduce yourself?
I like to address this from digital tools available to analyze algorithms for transparency reasons. I come from a small consultancy group that I had, and I worked for banks, in the corporate world, government. The way they are using analysis, it's a very methodical, focused one. For this platform, social platforms, to be analyzed, maybe we could borrow from their expertise. Let's take an example. Let's look at the algorithm. If I don't make sense, please interrupt me in here. You talked input to algorithm, you call data coming out of the algorithm, and the algorithm mathematical formulas. Mm-hmm. Each together, I would believe, as a professional, wouldn't give the entire story. What will tell the story if Facebook would show us their use cases? What does it mean, a use case? Mm-hmm. I want to add a new customer. I have a registration, and I end up with a profile. And I want to know what goes in my mm-hmm. profile. And if you have a flag that you flagged me as a security, I want to how you do follow up on me.
Yeah.
That's what I think would be.
I agree with you. So I mentioned this only briefly in my prepared remarks, but so Facebook's terms of service prohibit not just scraping, not just collecting data through computer code. They also prohibit what they call fake accounts. And in most contexts, what counts as a fake account is obvious. If you create an account that's not associated with a real name, it's a fake account. But researchers and journalists sometimes want to use what Facebook would call fake accounts and what researchers and journalists would call temporary research accounts to probe the platform for precisely this reason. So you create an account in which you post that you're a member of the Democratic Party. And you create another account in which you say you're a member of the Republican Party. And you can see then, how does Facebook respond to you? How different are the responses? And this is a very important thing. Because the algorithms don't tell you everything. You need to know how the platforms respond to certain prompts, right? And this is, in the offline world, there's a whole line of cases, at least in the US, that protects the ability of civil rights researchers to go to landlords with test with testers, and you send one white couple to the landlord, the next day you send a black couple to the landlord, and you see how does the landlord respond differently to people who are otherwise similar but differ in this one key quality. And journalists and civil rights researchers want to do the same thing on Facebook's platform. They want to find out, well, if you're black on Facebook, what is the experience of being black on Facebook, and how does it differ from the experience of being white on Facebook? What is the experience of being from California on Facebook, and how does it differ from the experience of being from Toronto on Facebook? And it's impossible to do that kind of research without violating Facebook's terms of service. So the safe harbor that we propose and the safe harbor that I referenced earlier would protect not only the ability of a researcher to scrape the platform, it would also protect the ability of a researcher to create what Facebook would call a fake account, to do that kind of work. Now, Facebook has said, we want to create a community in which people can feel confident that the people they're interacting with are real people and not bots or machines or fake people. And so what we've proposed is that they allow researchers and journalists in certain contexts to create these temporary research accounts so long as the accounts themselves identify themselves as fake accounts, right? So, but there are many contexts in which what you're trying to study is not the activity of other users. What you're trying to study is the activity of the platform. And so you're not really interacting with other users. And to the extent you are, you would disclose to those users that this is not a real person. This is the New York Times doing a study of Facebook. We'll see how Facebook responds to this suggestion. I mean, they did not jump at it, but nor have they said that they're closed to it. Good question.
Let me now ask a question. We have had the chance to speak about this. So your discussion is very much couched in American idiom, right? So Facebook is an American company. You're from an American organization, and you're having a dialogue within a legal framework that is American. And that makes sense, right? Mm-hmm. To the extent that you approaching Facebook on those terms and them being willing to, say, amend their terms of service or their approach in a self-regulated way, and so far as that works, fantastic. The sense is that might not be the end of the story. And so the worry here in terms of strategy is having that discussion in a context like the US, which has a very specific, not to say idiosyncratic, understanding of freedom of speech, which is, as you said, very user-driven, very pro-corporate speech, campaign finance, Hobby Lobby, Citizens United, cases we're all familiar about, is the worry that the kinds of outcomes of that discussion, say, whether it ends up in the court or even at the level of Congress, entrenches further some of these idiosyncrasies, makes me think that it might be worth thinking about approaching other avenues or other venues from a transnational perspective, going to the EU, coming to other jurisdictions to have that discussion in order to be able to try to have it in a less idiosyncratic way, right? So we've seen Google having trouble in the EU, and my terms of services here in Canada changed as a result, right? So to what extent do you think it's prudent, I want to say, to cabin the approach to the US, and to what extent do you think it would be worth engaging other jurisdictions?
No, that's a good question. I mean, you're absolutely right that I've approached this through a kind of American lens. I would say that the extent to which it would be productive to approach it through a different lens depends a little bit on which reform we're talking about, right? So if we're talking about pressuring the companies to be more transparent, there's no reason why that kind of campaign should be an American campaign. There are users of these platforms all over the world, and we're not relying on law in any direct way in pushing for this kind of reform. It's a softer ask, and it would make sense to have a broader coalition, and that's something that we should definitely explore. When it comes to persuading the courts not to enforce terms of service, it's hard to get out of a single jurisdiction, right? They're the cases we'd have to rely on in asking American courts not to enforce terms of service are American cases. And we're stuck with the idiosyncrasies of American law in that context. And there is a sense in which we could put together a broader, that we could have groups in multiple countries going to their own courts and, making the same arguments, but they would have to make the arguments in very different ways. And even, whether the argument could be made or not might turn on what jurisdiction you're in. I mean, this is not an easy argument in the United States. It might be an easier one in countries where the public interest override to contractual agreements is stronger. There's more in the United States, as you can imagine. It's this very high deference to private contractual agreements. And then this argument that the CFA, the Computer Fraud and Abuse Act, violates the First Amendment to the extent it prevents this kind of journalism and research. There, we're addressing an American problem because it's an American statute, and I don't know that there are similar things in other countries. Maybe there are, but I don't know. And we have no choice but to use American tools to get at it. There, I think the problem is especially American in that the CFAA reflects this use of government power to protect private interests, and that's the kind of thing you see more in the United States than you do anywhere. Private economic interests, right? But the solution, our argument that this statute violates the First Amendment or violates free speech rights to the extent it prevents this kind of journalism or research, my sense is we have stronger tools at our disposal in the United States to fight against a problem like this than you do in most other places in the world, because free speech doctrine is very well developed in the United States, for better and worse. It's an entirely plausible argument that this statute could be struck down as applied to journalists and researchers on First Amendment grounds. So I think that this set of problems would definitely benefit from the thinking and resources and experience of a broader and international coalition or group. But the value of that might be different depending on which reform we were talking about.
Thank you. My question was about jurisdiction too, but I'm gonna now. Can you take us back to the original story and The Guardian, and take us to the offline legal scene? What happened with that threat to sue The Guardian?
The short answer is they backed down. Facebook backed down. I think
the arguments.
So they argued. The Guardian, their hook was that the Guardian described this as a breach, as a data breach. And Facebook, the hook for Facebook's letter to the Guardian was that it was libelous or defamatory to describe this Cambridge Analytica thing as a breach, because it's not that Facebook had data in some on some hard drive somewhere and somebody hacked into it and exposed it. That's not what happened here. This was a combination of data that individual users had already made public in some sense, they had posted publicly, and other information that users had voluntarily given to this researchers in return for small sums of money. And so Facebook said, you absolutely cannot publish that. Your story is completely wrong. The framing is all wrong. This is a much more minor problem. And to call it a breach is, not just wrong, but actionable. Now, I don't think Facebook was really concerned about that narrow point. What Facebook was concerned about was the story, more generally. And The Guardian, to its credit, just published the story. And the aftermath of the story was that Facebook was, under fire from, from many different places, and Facebook predictably decided that it was probably not in its interest to be seen to, be going after The Guardian for this story. And so Facebook sort of changed its attitude towards the story after it was published. But you see that, now we represent these journalists and researchers that are trying to study the platforms. And those kinds of conversations happen all the time behind the scenes around the Terms of Service and the Computer Fraud and Abuse Act. Like a journalist will, so we represent one journalist who came up with a tool that allowed people to study why Facebook was recommending certain people as friends in the Friends You May Know, People You May Know feature. So if you use Facebook, there's a feature called People You May Know, and it recommends people to you. And this journalist, Cash Hill at Gizmodo, was studying this particular feature of Facebook and interested to find out why certain people have been recommended to her. And one of the people that Facebook recommended to her turned out to be like a long-lost relative of hers, and she didn't even know this was a relative, but she did some research and she found out that Facebook somehow knew that this was her relative even though she didn't. And she thought, well, this is interesting. And so invented a browser plugin that individual users could install and track the people who Facebook was recommending to them. And Facebook contacted her offline and said, we think that this tool violates terms of service, and we think you might want to take it down. And she got in an exchange with them about, can you explain to me how this violates the terms of service? Because this is a browser plugin. It's not obviously in violation of the prohibition against scraping. It doesn't involve a fake account. So what is the term that it's prohibiting? And I don't think she ever got a satisfactory answer to that question. But they tried to bully her into abandoning this project, and she didn't, to her credit. But many journalists abandon projects in the face of the veiled threat of legal action, or not so veiled threat of legal action. And so the same kind of thing that you see going on with The Guardian goes on every day behind the scenes, and there's no easy way to track those kinds of conversations. And we have no idea how many projects have been abandoned because Facebook or some other platform said, hey, you know what, there's this federal statute called the Computer Fraud and Abuse Act. And they may, as they're doing with Cash Hill, they may be invoking terms of service or the Computer Fraud and Abuse Act, even when those things don't actually apply to the project that the journalists or researchers engaged in. So that's part of the reason why we thought this safe harbor idea was worth pursuing. Yeah.
One last question.
Hi, so my name is Luca, and I'm just a first-year student here at Osgood. And my question was related to the EU, and you mentioned them briefly in your speech. And I just wanted to know your assessment of how they're handling it, because I see that they're taking broader steps than other countries or like North America or Canada in terms of curtailing this. Yeah. And with specifically maybe to the copyright directive that they've recently done, because there's been some public backlash to that. So I'm not sure how you assess their strategy on the digital single market.
So I don't know a lot about the copyright directive. I think my general sense is that the EU has been more thoughtful than the United States when it comes to privacy issues. I'm worried a little bit about their response to what they see as dangerous speech. So they have, in Germany, there's this new law that requires the platforms to take down speech relating to terrorism, for example, within, I think it's 24 hours. And the way these categories of speech are defined is often unsatisfying, and the platforms have every incentive to over-censor, to take down much more than might fall into those categories, because the liability is significant, and there's no penalty for taking down more speech than you have to. And most of the speech that is taken down, some of the speech that's taken down, everybody would agree this is inciting people to terrorism or inciting people to immediate violence. But a lot of it isn't like that. A lot of it is stuff that's controversial or involves groups that are disfavored, but doesn't involve, sort of the kind of speech that most people would agree governments have a legitimate interest in taking down. And the costs of that kind of over-censorship often fall most on marginalized groups, marginalized because they're politically marginalized or religious minorities or racial minorities. I think that there are trade-offs here. In the United States, there's a good argument to be made that Twitter, for example, has which has used to call itself the free speech wing or the free speech party, right? Because they generally didn't take things down. One consequence of their not taking things down is that a lot of harassment stayed up on the platform, and there too, the groups that pay the most significant price for that kind of harassment are women or minorities of one kind or another. And it would be hard to call that a free speech success, but on the other hand, you don't want the platforms to take down so much speech that you end up with these carefully curated spaces where controversial ideas are marginalized. So you have to find some middle, some middle road here. On the speech issues, I'm not convinced that we've found it. Privacy, I think that the EU seems to be a good step ahead of the United States. And on antitrust issues too, the EU has been much more aggressive with the big technology companies. And now you see, for good reasons and bad reasons, the the Trump administration more interested in anti-monopoly litigation or regulation of the tech companies, but we're definitely behind.
All right, so Jameel started his lecture by confessing doubts as to whether his lecture would live up to the title of the Emet lecture, that is, The Light of Truth. Now, after listening to this lecture, I think you'll agree with me that he's really made a valiant effort to shed light on an issue that really warrants more inquiry, and that he's been the lecture really champions eliciting facts, access to facts, greater access to truth in an area where even those who are putting out the truth, that is companies like Facebook generating algorithms, do not know what that truth is. So it's hard for me to think of a topic for a lecture, for an Emet lecture, that was more appropriate. So please join me in thanking Jameel Jaffer for what was really a great Emet lecture. Thank you very much.
Thanks, Michael.